From We Are Spectacular, this is the Spectacular Marketing Podcast, a podcast about everything brand, marketing, digital and social for the food and drink industry and beyond. Hi, it's a warm welcome from Glasgow today, where I'm up visiting a few friends and family over the next couple of days. I've also managed to squeeze in a couple of podcasts, you'll be pleased to know, and this one today is all about intellectual property and why it's important for you to protect your brand. Today I'm speaking with Stuart William Wallace, and Stuart is the founder and CEO of S. William Wallace Company. He's been a practicing UK chartered and European patent and trademark attorney for the last 20 years. Stuart is our go-to guy at We Are Spectacular in terms of protecting our brand, but also protecting the brands of our clients. We spent around an hour having a really great discussion about all types of brands, big and small, and also talked about why it's important to protect your brand for future, and also that it doesn't need to cost the earth. It gives me great pleasure to actually do a podcast up in Glasgow with my oldest friend, Stuart William Wallace.
Hello.
Which sounds very Scottish and very warrior-like. But he's certainly the guy that I have fighting my corner in things like brand protection and intellectual property. So a man much more cleverer than I'll ever be. And really helps keep me and our clients out of court, which is a really positive thing.
Oh, you're too kind.
So I can't believe you dragged me all the way up to Glasgow to do this, but
it's sunny today.
It's sunny today. It's like 10 degrees or something. So
it's the summer.
Positively Iberic. But I think in terms of doing this, it's just such a great way for people just to get knowledge that they wouldn't normally get for free.
Yeah, I hope so, and I hope your listeners will have a little bit better appreciation of what intellectual property does and how it serves them, because every business has some form of intellectual property, and most of them probably don't know what it is or what it's doing for them. Mm. But there's tremendous value in intellectual property. If you consider the great brands of the world, yes, they spend a lot of money on promoting their brands and maintaining a market share, but ultimately it's the ability for them to stop other people from using either those brands or confusingly similar brands that allows them to exist in the marketplace in a fashion that keeps people coming back for more Coca-Cola, more McDonald's. It's not what they spend on marketing that stops other people from doing that. It's the fact that they can protect them by registration or through use that will keep others off their patch. Mm.
Well, I think it's really interesting. We've just sort of jumped straight into it, and I think, what a lot of clients come to us, a lot of people you're just talking to that are established, companies and brands, and they'll say, but we're not a brand, because they don't feel like they're big enough, or they don't feel like they're a chain. It's the C word.
Yes.
But really, I've always kind of thought about it where it's been like, if you have a competitor and you take money, you're a brand.
Yes. Everyone, in a legal sense, we call brands trademarks. There's a registered trademark act. And legally what a trademark is a sign which helps a consumer make a purchasing decision. Essentially, that's how we view them. So if you wander into a shop and you're thirsty and you have a choice between Coca-Cola and Pepsi-Cola, then it's the trademark which guides you towards your preferred cola. It's a badge of origin. It makes sure that if you buy the cola in the red can, it's going to taste the same as the last time you had the cola in the red can, rather than the cola in the red, white and blue can. And Coca-Cola are a good example of what seems on the surface to be a fairly simple brand, But if you look in depth at what they protect Coca-Cola, they protect Coke, they protect their ribbon device, they've tried to protect the colour, I believe. They also have protected, most famously, the bottle shape. Because if you see a bottle of Coca-Cola, without seeing the branding on it, you'll still recognise it as being a Coke.
I think it's quite interesting because a lot of people will then say, well, it's the product of Coca-Cola, but it's all sort of intertwined and intrinsically linked. And, one of the things we always talk about, and, a great brand guru that we know and love, Robert Bean, and he's going to be on a future podcast. And Robert talks about a brand being a promise delivered.
Yes.
And it's not just the brown liquid, right? It's what that says about you. And as you see, that consistency. And it's almost like a fashion item. And I think something we talk about a lot when I come to you saying, look, we've got this project. You talk about the risk of passing off or the risk of, straying into someone else's classification. And and it's almost the great advice you always gave to me was, if it just even seems like a 1% risk, don't do it.
Yes. You often have clients who will want advice and say, well, how close can we get? And the concern that you have is not only the potential for there to be a legal problem, for someone to be so aggrieved at what you're doing to issue proceedings or take action against you. Because if you have rights in a brand, either if you've registered them as a trademark or you've used them long enough that you have a reputation, and this is where passing off comes in. There's two slightly different mechanisms by which a brand feature is protectable. And I know when you're speaking to you put a lot more into what you consider a brand aspirations, all sorts of, I suppose, internal machinations that we as legal advisors don't really get involved in. Trademarks tend to be the external surface of a brand. It's what kind of shines out and says to the consumer, this is the brand you were looking for. And the two main mechanisms by which they are protected is you can either register them as trademarks, and as soon as they are registered, if they're accepted for registration, you have the right to sue someone for registered trademark infringement if they either use the same brand that you have registered or brand feature, or they use something so close that it's likely to confuse the consumer into believing it's the same thing. And many years ago, just going back to the cola giants, in Canada, Coca-Cola tried to sue Pepsi-Cola back in the 50s, I think, just on the basis of cola. And they thought, well, that's too similar. I think Coca-Cola were kind of putting their weight about a bit. Yeah. It was eventually determined, well, that isn't the distinctive part of your brand. Cola is just the description of the product that's in the can. It's Pepsi versus Coca or Coke that makes the difference. And if you register that feature, be it a name, be it a logo, and something is used by a third party, which could cause confusion and cause a consumer to pick up their product thinking it was yours, there's trademark infringement there. The second way in which a brand is protected is through use. And this is a much older form of right than registered trademarks. It's called the common law tort of passing off. T-O-R-T. Yeah, tort is to civil law what crime is to criminal law. So, and if you've used something for a long period of time and people associate that with you, then you've got a goodwill and reputation in it. And if someone misrepresents what they are doing by using that feature or using a name which is similar and it causes you damage, loss in sales, loss in reputation, or even that there is the possibility of damage being caused, then you can sue them for passing off. And often you find that if someone is being sued for trademark infringement, they'll usually be being sued for two things. They'll be being sued for registered trademark infringement and passing off. And sometimes both will be in place. Sometimes one will only be in place. Sometimes people can be sued simply on the basis of a registered trademark, and there has been no use of the mark. And in the UK and Europe, if you have your trademark registered, you can sue people for 5 years from the date of registration, and you don't even have had to have used the brand. So it can be an incredibly powerful tool in keeping your brand free of the white noise around about it, which can confuse other people. The benefits of registering your trademark, in addition to simply just using it and relying on passing off to protect you, is, first of all, you get rights immediately. You don't even have to have used the brand in order to have your right to prevent someone from using your trademark. It also appears, as the name suggests, on a register. And the register is there so that people can go along and see, I see Coca-Cola have rights in that bottle shape, I better not use that bottle shape. It's there as a public record of what rights are in effect. And much like the other registered intellectual property rights, such as patents, which protect technical innovations, registered designs, which protect the aesthetic appearance of products, which are perhaps not as important to the audience as registered trademarks. It's there to be viewed. It's not a secret what people have protected. You can go to the register, you can look up what is there, and increasingly, thanks to the power of technology, it's even easier to go and check what is there. Because I mentioned that not only do you have protection over the brand that you have registered or the trademark that you have registered, but you also get a penumbra of protection around about that if a trademark is too similar to yours, there can still be infringement. If either there is a likelihood of confusion or you have such a massive reputation in the marketplace that it would take unfair advantage of your trademark or be detrimental to it. So a trite example, spelling Coca-Cola with K's is not going to prevent you from infringing Coca-Cola's registration with C's. It's virtually the same thing.
Well, that's really interesting because, there's a few brands that I can think of out there in the food and drink space that are doing, almost exactly that, but in different territories. So, where they are just kind of switching out a letter. And I think, we will come on to, where do you even start with all this? Because I think the stuff that you're talking about is just so overwhelming for the small business owners to think, where do I start? But the first thing that really sort of ringing through in my head is, it feels really like the Wild West out there a bit. And I mean that from quite a few areas. I mean that from talking about my own peers, so the agency sector, where there's pressure on them to come up with great brands, great names, and a lot of the great names and great brand names have been taken. So it's hard to do something really differential some of the time. And then also making sure, being selfish, that you're protecting yourself and your own agency. So what we would normally do in that area is we would do name generation, and we would do like desktop research as a bit of a first stage, search Google, things like that. And then we would either go to routes and we would say, look, Mr., Mrs., Miss, Master, Client, you then take that into your legal department and or pass off, not in that way, or pass it over to someone like you and say, could you check this in all the proper ways? But my other fear, so I think there's the agency part. I think there's also the brands part, and I'm talking about large brands who actually make brands on like a daily basis. So they franchise things, they come up with new concept things. And again, I'm not 100% sure how much due diligence is really going on to do that. And then the one that really worries the pants off me, and, thinking about those guys because they're so small, is the craft beer movement. And the amount of name generation that's going, and I honestly think an IP lawyer could probably have a field day there with so many things looking like each other, sounding like each other. They've all got hop in the name, or there's some pun on hop, something like that. So, I think in the restaurant industry, definitely, and certainly in the smaller, more independent side, I think that we're actually a little bit protected, naive, not looking over there. And I think, as this, we were just talking about this earlier, the Jamie side of things and Byron and everyone overstretching and all these kind of things. And, I hope to God that, the best ones survive, that's for sure. But part of that is getting your brand in order in the first place to make sure that you create that standout, right?
Yes. And there is always that worry. But, if you worried about everything, you would never do anything. And I think a sensible balance between cost and time on searching, and Google, or if you want to use Bing, other search engines are available.
Not many.
That is a good first step, because there are plenty of people who have not registered their trademark. Does that mean you can register the same trademark if you've perhaps come up with it independently? In some circumstances you can. Let's say, for example, there's a single restaurant in Glasgow and a restaurant opens up in Brighton with the same name. If no registered trademarks are involved, there's unlikely to be passing off, because the geographical extent of the reputations will be limited. Now, let's say a restaurant in Glasgow decides to register its trademark. If it registers its trademark, it may be able to hem in Brighton restaurant to where it was operating at when it filed its trademark application. Or it may be able to prevent Brighton restaurant from operating. The best thing to do, I would say, is have a list of potential brands that you want and work through them before you invest too much in a particular name. Work through them. Spend an hour on Google. If your restaurant name is Blogs, put in Blogs Restaurant in Google and it will find it. And if it's something in the UK, chances are there could be a potential problem down the road. Your decision at that point is, do I want to take this problem on? How invested am I in the name, or can I move on to plan B? Also, in addition, the UK Trademarks Register has a portal at www.gov.uk, and I'll give you the full URL when I find it. But you can go there and you can just type in the name that you're interested in. And it's quite a powerful algorithm now. It will not only return the marks which are identical to that, but also ones that may be deemed similar. And again, if you find that there's a blog's already registered in class 43 for restaurant services, chances are there might be a problem, and then you have to take a decision, how invested I am in this. Because it doesn't mean to say that is the end of the story. Let's say we find a registered trademark and it's been on the register for 10 years. Now, immediately I would be thinking, well, is that still enforceable? Because it's quite an old registration. And if a registration is out of use for 5 years, it can be revoked, it can be knocked off. So you can go from there, you can look at the company name, you can search in Companies House. Is that company still in existence? Has it gone bust? Does it mean that potentially the registered trademark could be dealt with or could be purchased for your benefit? If you find a restaurant that's in an operation, perhaps you could write to them and say, well, we are interested in using this name in certain areas. Would you be all right with that? In most cases, if I was the person being approached, I would say, no, I'm absolutely not okay with that. Because the last thing that you want is, let's say, for example, we've got our two restaurants, one in Glasgow, one in Brighton, and the one in Brighton has a terrible outbreak of salmonella, and it's all over the newspapers. That's invariably going to affect the restaurant in Glasgow, even though it has nothing whatsoever to do with the restaurant in Brighton. There's going to be an assumption that it's the same place because of the same name. It's
so gutting, as a Scottish word, gutting. that, yeah, some of the name generation sessions that we have, and, sometimes it does include beer, and we come up with what we think is just great. And we start there because you don't want to limit the thinking.
Yes.
And we had one for a coffee client, actually, and we just came up with the best name for it. And anyway, funnily enough, there was a cafe in Brighton called that. And we decided in the bunch that we didn't want anything that could stop, almost global reach. And what I was thinking about there, just as you were talking about that, was there's a great Alfred Hitchcock quote where it's actually in the Stone Roses movie at the start, and he says, what's happiness? So it's almost like, what is brand happiness? Mm. And he says, nothing on your plate and a clear horizon.
Yes.
And it almost is like, that would be the right thing. That would be the right approach. No fly in your ointment at all, because I know that you're maybe just starting. We've just seen a great little chain popping up all over Glasgow. They're called Peace. So Peace for non-Scottish speakers is a sandwich, a piece on ham or a piece on jam, whatever. And they just seem to be kind of everywhere. But, it might go great. And what's going to happen when you go for chain 5, chain 6, chain 7, and in restaurants they always talk about 7, 17, 70. Mm-hmm. So the first one happens, then you get to 7, it all changes, 17, and then by then you're into investment and whatever. And from that point of view, you want to think like a 70 even when you're 1.
Yes.
But the trouble is, I guess, with people who've got a passion for food or hospitality, or that's not their game, so the brand to them is just the name above the door or a colour or a thing, and, they don't know what they don't know.
Yeah. And I've been practicing for almost 20 years now, and I always recognise it's very easy for me to say, you can't have that one, come up with another one, and not really appreciating the amount of work and effort and investment that's gone in to get the first name.
It's not even that. That's part of it, right? But it's just people, it's like a new puppy or something, right? Where the people get so emotionally attached to this, they can just see themselves in that name. Mm-hmm. And then that's where compromise starts. Mm-hmm. And that's what then will unravel, sort of down the road, which is a real shame.
Well, like you were saying, the 7, 17, 70 thing, it tends to be like that with intellectual property problems, where you could start up one restaurant with a name, not having considered any trademark issues. Everything's going great. You haven't heard from anyone. You open up a second one. You begin to get some buzz and some traction. And just before you're about to open the third one, you get a cease and desist letter. And then you have to consider, how much does it cost you at that point to change everything? And not only that, there's a concept, mentioned it before, goodwill and reputation, that you build up as you are using a name. And you become known for that, and known for a certain quality or a certain experience. And if all of a sudden you have to change all that, then no matter what you do, I think invariably your goodwill and your reputation is going to suffer. Because we all remember GIF to SIF.
Why did that happen?
I don't think it was a legal problem. I think they had different brands operating in different areas, and they wanted a consistent message. Normally trademarks, the same trademark can operate in different areas, and there is legions of examples. For example, Polo Mint, Polo Cars, Polo Ralph Lauren. They're all Polo, they're all famous brands. But when you buy the mints, you don't think it comes from Volkswagen. When you buy the car, you don't think it comes from Ralph Lauren. When you buy the shirt, you don't think it comes from Nestle. There's no confusion. Penguin is another example, with biscuits, books, and clothing now. They can all operate independently because we are not confused. Consumers are kind of treated as almost like an idiot savant in registered trademark terms. They know a certain amount of things, but they can be confused quite easily. So, for example, they might be confused between beer and cider.
Yeah.
But they're not necessarily going to be confused between a car and a confectionery. So it is possible, and that's sometimes why you just have to take advice and ask someone who's qualified, do you think it's a problem? But normally I would say if your spider sense tingles and you think there's going to be a problem, I would say chances are there is going to be a problem.
Yeah.
When I am looking through a trademark search report, you try and put yourself in the mind of the average consumer, and you try and, bring all these things like imperfect recollection of brands and all these various things. But ultimately...
So what's that, Stuart?
Imperfect recollection is that you may have seen a brand a couple of times, but you might not remember exactly how it's spelled or exactly how it looked.
Right.
You have an imperfect recollection of the brand. And that can lead to further confusion when you see a brand which is similar. I suppose the more that a brand invests in advertising and promoting their brand, the less likely you have imperfect recollection. But, in the vast majority of cases, being, small to medium-sized enterprises like you and I, you are not going to be able to put behind your brand what Apple can put behind its brand.
Yeah.
So there's always going to be a possibility of this imperfect recollection. And as I said, when I do trademark searches, my thinking always leans towards, well, would I be confused?
Aye.
If you're out, you've had a couple of drinks, you wander into a restaurant, you have a good meal, you leave, you're talking to your wife or your partner afterwards. Oh, what was the name of that place? And you might have a sense of what it was. But if something pops up nearby, which is quite similar, then you could just be confused into thinking, well, is that the same place? Is that the same chain? There was two nearby that one is closed down. Bread meets bread.
Do you know what? I was just going to talk about this. So go on.
Bread meets bread, which is meats spelt, like meat, like beef and so forth. And there was one just down the road from us here on West Regent Street, which was, I think, bun meets bread or something. They had gone very, very close. And every time I walked by the second one, I thought, you are just waiting for something to come across your door that you're not going to like.
Well, it's funny, there's quite a few huge fans of, Meat Liquor and all the guys there. And there's like 10 Meat Liquor rip-offs in every city now. I mean, even just walking around Glasgow, you just see meat written everywhere and all that. And, really, again, for those guys to get the credit for how good that stuff is. And I'm sure these other operators are doing a good job, but it's like, just need a bit of originality. And it happened with the Burger and Lobster as well. So then all you saw was steak and lobster or burger and crab and just people, and there was an independent in Brighton, so it was lining itself up as that, and it literally had in the window chalked up, with those chalk pen things, burger and lobster, or maybe they switched it. And it was a bit like, honestly, if I wasn't working in the industry, I would definitely have thought that was that.
Well, I think one of the things that hamstrings a lot of these brands, if they're very descriptive, they can be difficult to register, and they can also be difficult to show that you have rights in them as a brand. If you use them for a long time and people begin to recognise them as a brand, but steak and lobster, that's what they're selling. So there's an argument that they can just say, well, that's what we're selling, that's what's on the menu, that's not our brand. Our brand is such and such. And it's always a good idea if you can, and again, I appreciate it's easy for me to say, be more distinctive. But if you come up with a distinctive brand, Kodak is generally the favourite because it means nothing else. It just is a brand.
It was a made-up word, right?
Yes.
And Evian was the same, was it?
I think so. There's quite a few.
But then someone told me about Evian being naive spelled backwards as I was drinking a £2 bottle of water, which I always thought was a good one. But yeah, I mean, I think those real emotional... Now, you're really right, in terms of, if I don't know, Eat or Pret or one of these had actually went, sandwich shop or sandwiches
Yes.
or, you know, then you're right with things moving with the times and people being anti-carbs now and gluten-free and da-da-da. 20 years down the track, you don't know what's going to happen, and what if there is a lobster scare, or lobsters goes through the roof, which it is, or we are going to start running out of meat, so you might need to be looking at alternatives there, and it's tricky. You know, I think it really needs to be, I think emotional over rational every time, really.
I don't know if there is. There tends to be at the beginning a predilection for a nice descriptive brand, you know, tell them what it does. But long term, if you're looking at the trademark side and the status that you want to get to, where I'm sure everyone in the world would like, if they come up with a brand for their restaurant, that will be exclusively associated with their restaurant and no one else will use it around the world. And they could move into any marketplace when they're going from, you know, 70,000, that they will never have a problem in any marketplace with that. That's probably unlikely to be the case. But the more distinctive your brand is at the start, the less likely you are to run into those problems down the line. You know, with the scenarios that you outlined there, I'm aware, I've seen them as well, the neon light spelling out meat and liquor, but that's what they serve. And their immediate defence would be that, well, we're serving meat and we're serving liquor. It's not a brand, it's just what we do.
But I think the cute thing about meat liquor was it was like just so punk in the way it was added together. And in the UK, no one really said liquor. And no one really described it as meat. So it's a weird one that I see that as a very emotional name, although it's descriptive. But, you know, but then, you know, they've got the interiors are much copied and, you know, the whole thing. But, you know.
Names, they can acquire distinctiveness as they're being used. So, you know, meat liquor, at the very start, somebody walking past probably thought, well, they must serve meat and liquor in there. I'll go in. But the longer that brand is out there, the more it begins to be associated not with a description of what is being sold, but as a brand that is recognised as them.
And an experience.
And I suppose the flip side is you would probably tend to get less protection if someone made more changes. You know, if somebody, liquor and meat. Would that necessarily infringe meat liquor's registration? I don't know. I'd need to think about that.
It'd be a real tough one.
And if they were certainly, and passing off is, you know, a kind of broader thing. So if the whole restaurant experience between meat liquor and our hypothetical liquor and meat, if they were very, very close together, you know, it was the same kind of decor, the same kind of meat, well, potentially you could have a situation where you don't have registered trademark infringement, but you might have passing off.
But I think, you know, the advice for anyone going into it, and, you know, agencies and brands and products alike, it's just make sure you've got that clear horizon. And I think, like, in terms of one of the first things I always do and look at is I actually end up going to social media handles and URLs. That's always my first point of call. 123reg, still old school. It's actually, its search function seems better than GoDaddy's for some reason. Lists out more, but then, you know, usually go with GoDaddy. But in terms of that, you know, I always find that's a good way to do it. And the thing that we talk about for social media as well, kind of getting into that identity side of things, is try your best to always have the same handle across every single social media channel. And there's nothing that pisses me off more as a consumer when I actually want to, you know, tweet someone and then the whole thing is, you know, *_bucks and things like this, right? And it's like, they've just not got that in order. And that just feels like basic brand housekeeping to me, because it's not that, you know, people call you Stuart, but they'll call you Jason on a Saturday. And, you know, it just doesn't really work like that. So we're always kind of imploring that you want that royal flush. You want that full house where you're basically going, I've got the URL, the name's clear, the identity's clear, you know, and all that sort of stuff.
Big Red, Coca-Cola is another great example of that, because they were always Coca-Cola. And I think in the 50s, people started shortening it to Coke. And so they thought, well, we should start using that and start protecting it. So I think still now, if you look on the back of a can of Coca-Cola, you'll see them using Coke, but it caused nothing but problems for them. There was this, again, what you were mentioning, there's a split. Well, are you Coke or are you Coca-Cola? What are you? And then you get the worst situation, which is sometimes referred to as dramatically as genericide, is where a trademark begins to be seen as a description of a particular product. So Coke began to be associated with cola. The actual product description, people would ask for a Coke. The classic, give me a Coke, we've only got Pepsi, whatever.
Is that okay? Yeah.
Same with Hoover. If you ever see your registered trademark appearing in a dictionary, then write to the dictionary and get them to take it out, because it's not a good thing. And it happens so often with so many brands that are so famous. Hoover, Hoover, in respect of vacuum cleaners in the UK and Commonwealth countries, has no value. If you attacked that registration and said that it had become merely a description of the product, you would probably win. I don't think anyone has ever tried it. Probably get too much respect for Hoover, but there was even a famous patent case between Dyson and Hoover, and throughout the judgment, even though he was dealing with Dyson and Hoover, the judge kept referring to Hoovers as vacuum cleaners.
Right.
And that roll plug, you're always going to be aware of it, that, this is a, trademark product name. It should be used as an adjective. Yeah. This is an Apple computer. Yeah. It's not an Apple. It's an Apple computer. Yeah. I suppose technically, you take it to extreme. This is an iPhone phone. Yeah. But
you're not going to say that.
You're not going to say that. But be mindful of it. Yeah. Be mindful how you're using it, because you can lose value straight away. Roll plug, I used to deal with back in the day, had the same problem.
Yeah. It's interesting because, like, in the food and drink world as well, there's stuff to think about. So you've got, there's a couple of brands that spring to mind that are in a category of one. Mm-hmm. So one is Wagamama.
Yeah.
It's a category of one. You're not going for a ramen or a this or that. You're going for a Wagamama. And that's, that is its own thing. Mm-hmm. And I'll be interested to see how that might play out going forward. And also Nando's, I think, is the same thing. Again, people don't talk about going for chicken or a burger, or they're going Nando's kind of thing. So I think those are going to be interesting, that they might become so famous that they become the watchword for that type of cuisine.
And it does tend to be if you have a monopoly or a quasi-monopoly. And sometimes if you have a brand associated with a patent, so a patent means that only, one person can make the thing, whatever it is, then in those cases, there's a lot of cases of genericide, paracetamol, aspirin, all these kind of things. They become associated with, a particular, product, salicylic acid, rather than the product of Bayer.
Yeah. And I was just thinking then, kind of going back then, so let's say we've came up with a new brand.
Yes.
And it's called, looking at the painting on the wall in here, it's called Armadillo.
Yes.
Right. And it's Armadillo sandwiches, whatever. And yeah, maybe not. And then I then call you up and say, desktop research looks good. Mm-hmm. The URLs are free. The social media is free. Probably people are trying to buy that right now as we're saying it. And then you do what? So what I'm kind of interested in is the process you might go through, all the things you need to trademark or apply for. And then things like, what are the starting costs for these things? Because I think so many people are like, Christ, this is going to be an absolute fortune. And I know myself that it's really not. Mm-hmm. So it'd be good to kind of talk through that.
What I would normally say is, first of all, let's do a proper full trademark search in the countries where you are interested in using it. So if you come along to me and say, well, we're going to start out in the UK at the moment, and we're not really going to be bothered with either the Republic of Ireland or anywhere else in Europe or US. We'll leave them for another day. Then we do a search through the registered trademarks which have effect in the United Kingdom. And at the moment, there are two main registered trademarks. There's UK registered trademarks, and there's also EU-wide registered trademarks. Now, with Brexit, that is going to change, but what seems likely is going to happen, according to EU white papers and everyone's desire, is that EU trademarks will continue to have effect in the EU, but if the owner doesn't have an equivalent right in the UK, then they're going to get a UK registered trademark, which is exactly like their EU trademark. And it will just
it's free, they'll just throw it in.
Yeah, the white paper said they didn't want anyone to have additional costs or have to go through any additional hoops to get that protected. Again, with Brexit, who knows what's happening?
Sure.
But those are the two main sources of registered trademarks rights. So we would go to the search engines. We would, and this is the UK IPOs, search engines, and put in the trademarks, get our searches so we get all the marks which are deemed similar, and look through them really and say, well, what does this one cover? Is the brand too close to armadillo? Is it a misspelling of armadillo? Is Amadea or something that could be too close? And what is it registered for? Because if armadillo is registered for cars, it doesn't cause us a problem, unless it's a very, very famous car like Ferrari. But I've never heard of an armadillo car, so I'm assuming it's not a problem. And if it looks clear from there, and that will probably cost you a few £100 to get a professional opinion.
What's a few £100 though? Is it 5 or 3 or 7 or what?
It depends where you go. I would charge £300 plus VAT for that.
I'm just being very Scottish about this. So, okay. So I've got £300 down, but I've got a clear conscience for now.
You've got a clear conscience. You have done due diligence. If anyone comes along to you and say, well, we did a search, we didn't find you.
Yeah.
In addition to that, if you've already done your desktop checks and nothing you have found out there in the marketplace, then you probably don't have a passing off problem either. Because if someone's not using it, they don't have a reputation, they can't use that angle to take action against you. And then you've got a choice of, well, do I register it in the UK or do I register it as an EU trademark? More than likely, if you're just interested in the UK, that's all that you're going to register. So we would go along and we would register armadillo. We've then got a choice for what do we want to register it for. And the trademarks register is split into 45 trademark classes.
Yeah.
And each of those cover a range of goods and services. Now, there's not a terrible amount of logic to how these classes are split up. For example, beer and cider are in different classes, whereas fire extinguishers and smartphones are in the same class.
Right.
God knows why, but that is the reality. So the more classes you want in an application, the more it will cost you. The official fees, if you electronically file your application, is £170 for the first class and £50 for each additional class above that. And if you're looking to get a professional like me to handle that on your behalf, we would probably charge about the same again in our professional fees.
Yeah.
So if you're looking at a one-class application, a couple of £100 plus VAT to put that together for you. Once you've selected the classes you want, you have to indicate what in the classes you're actually interested in. You can cover everything in the class if you want, or you can focus in on a range of particular goods you want. So if we are, we were talking about, let's see, we're setting up Armadillo as a potential peace competitor here in Glasgow. What do we want to register it for? Well, the main class is Class 43. That covers, sales of food and drink. But you might also want to consider, is there potential brand extensions that you also want to consider. For example, the food classes, class 29, class 30, beverage classes, 32 and 33, class 16, if you want to come out with a book with your recipes in it. And what you tend to find is the more classes that you add into an application, the more it will cost you at the outset. But it's often cheaper and better to have them all in at the start than to file separate trademark applications when you think 2 or 3 years down the line, we might come out with a book with our recipes, or is there some way that we can sell some of our recipes through a supermarket where you won't necessarily be protected for your sandwiches being sold in Tesco by your class 43 registration? You would want to have a class 30 registration covering sandwiches that are made up for purchase in such venues. Again, the more that you add in terms of classes, the more it will cost you. And there's always a balance to be struck. And you could go crazy with, apps in class 9 and software and so on and so forth. But again, it's about striking a balance. And I would say, for everyone in the dining, the food and drink sector, class 43 is the main one in which you should be protecting your brand, and also for searching for other people's trademarks that you may come into contact with.
Well, I think definitely the brand reach and the brand extension reach. I mean, going back a few years now, Oaxaca, who, love to bits, and we could not believe when they were only like 7 restaurants strong, they were in the middle pages of Boots magazine, that is the Christmas magazine that every household probably got in a bathroom somewhere or on a coffee table. And they were just punching above their weight so much. And I think that is such an exciting thing, because you can create supply and demand, but you can also create notoriety through just being, I think Leon did a super job of it, John and Henry over there with all their cookbook range and their crockery now in John Lewis. And I just think that gives you so many more grapple hooks on the mountain than just whether today's sandwich was any good or not. And I think if you're an entrepreneur and you're entrepreneurial about this, it's kind of a stitch in time scenario that even if you do then think you want to flip the business in 3-5 years time, whatever, it feels like if you've got that nice little suite of patents or copyrights or trademarks, or that then almost feels like planning permission when you're buying the house. Yeah,
absolutely. And one of the other things that's got to be borne in mind is always the possibility that you might not want to, prepare sandwiches for sale in Tesco, but with a registered trademark, it gives you the possibility of licensing someone else to do it. That you can say, we have this reputation, for our restaurants. We want to expand out. We don't necessarily want to do it ourselves, although that is a different conversation about whether or not the quality can be maintained. But the registered trademark covering those things gives you the starting point for a license, which essentially says, give me some money, make the product okay, and I won't sue you for infringement. And, we'll both get, something out of this. And if you look at, Nando's, I think still if you go into supermarkets, you can see their sauces and all sorts of their, ranges that, fans of Nando's can go in and buy and, attempt to make it at home.
And yeah, I've seen a lot of viral videos lately of young, fit, proteined up blokes drinking entire bottles of the extra hot sauce, which makes you just feel a little bit queasy. But yeah, I mean, I think that's a real smart move, and just allowing people to make that at home. I mean, I always think about the Pizza Express one, like, I never have a good experience at home because I usually burn it or whatever. But again, at least they're allowing you to take that taste back, and they were the real pioneers in sort of doing that.
And in the short term as well, it also increases your footprint. So if someone else comes along and they're thinking of doing a cookbook and wanting to use a name that's kind of similar there, if you've got a holding measure in there, a trademark which covers, books, potentially cookbooks, that you'll give yourself some breathing space, and they won't necessarily think, well, I can use it because it's registered in class 43, so I'll be okay.
Yeah. And I think it's that old adage, everyone's got a book in them. Definitely every brand has. I mean, even, back in the days of Pret and stuff, they did a sort of DIY cookbook, and it was just so thoroughly Pret through and through. And it was literally telling you how to make sandwiches, but it also had great life tips, which was, never trust someone that doesn't put butter all the way to the top corner of their bread, things like this, which was just kind of fun. The other thing, I was just sort of thinking about was, we've got the name, we've went through the due diligence, which feels like a couple of grand, maybe, tops. For you to, have a bit of safety and security for the future. That feels like...
Well, yeah, I mean, it's an insurance policy.
I was just about to say that, yeah.
Insurance policy.
Definitely. And I think that's a real smart move for someone. And what else? You might spend $2,000 on a neon sign for your shop, or you might, just think about where you could maybe fit that in. The other thing I was thinking about then was, what about identity and things like that? Then how do people deal with that? What are the risks?
Identity and...
Brand identity, the logo, maybe some strapline words, colours, that sort of stuff.
Well, all of these are potential trademarks and all are potentially registrable as trademarks. When we file our application at the trademarks registry, what they want to do is they are giving you effectively a monopoly over a word for the supply of services. If we register trade, you often see this misinterpretation in newspapers. Oh, someone's registered this trademark for penguin. That means no one in the world is allowed to say penguin. It's a lot of tosh. What it means is that is someone's brand. They're only allowed to use it to identify their services. Of course, everyone can say penguin. It doesn't do that.
David Attenborough would be out of job, right?
But all of these other things are potentially trademarks if they're distinctive. Now, if we come along and file our armadillo application, there's a possibility that an examiner might say, well, that's going to prevent people selling armadillo sandwiches, but that's not really, like a pork sandwich.
Yeah.
But that's not going to happen. They're not that
tasty.
Well, exactly.
I'm imagining, a bit tough.
No, but anything else, your logo could be distinctive. From here, I can see many logos on the top of your laptop. The Apple logo, the Adidas trefoil, the Nike swoosh, all of them function as trademarks. They're perhaps not as powerful as the name or the word trademark because they can only be communicated visually. So often I would say, well, make sure you've got your name registered. If you've got to make a choice, register the name because it's the name that's communicated visually, audibly, everything. You're unlikely to change a name, but you may change a brand identity. So you may change a logo, and the Apple logo is going through a few variations in its time, but it's still a trademark, and it should still be treated as. Essentially, the question should be: would I be annoyed if someone else used this?
Yeah.
And if the answer is yes, then you think about protecting it. You can then move into the more non-traditional trademark areas, and again, there are legions of examples. The red soles of Louboutin were in the news quite recently because they were involved in a court case about that. If it's recognised as a brand, then it's distinctive and can be registered. The starting point, unfortunately, with these non-distinctive brands is the public are not educated at the start to recognise them as brands. So the default position is they're not distinctive until you can prove them. So let's say we have a funny branding feature. Our couches are a certain way, or there's something funny and we want to protect it.
Triangular couches or something, I don't know.
Yeah, something like that. Something that we think is part of our brand. And again, the question is, would we be annoyed if someone used this and we want to try and protect it? There might be value in looking at registered designs because they're a lot more easier to protect because we are talking about the shape of a product. But if we're wanting to register these as trademarks. And the advantage that trademarks offer over designs is trademarks can function for services, and we are supplying services. Designs don't cover services, they cover products, and we're not selling couches. We're selling food with these couches. If we can demonstrate that people recognise our brand from these features, and we can gather evidence of that, and normally it's going to take you a few years to do that. You know, with Louboutin it did, with Cadbury's in the colour purple it did. A lot of these, which may be valuable, are, you know, great exercises for us as intellectual property lawyers, because it's an awful lot more difficult to get them registered. We have to bring an awful lot more evidence to the table showing that it has moved on from a quirky bit of decor into an actual branding feature. And again, with everything else, there's got to be a balance. How much is this likely to cost me against how important, how valuable it is to the brand? There can be value in simply just filing an application, and you put it on searchable record. And even if the application ultimately fails, if we do a search and say, okay, we'd quite like to use triangular couches. Oh, someone else has tried to register triangular couches as a trademark for the restaurant. Where does that leave us? Where it leaves us is an awful lot of confusion, and, you know, being risk averse, you would tend to say, if they've gone to the problem, or they've gone to the hassle of filing an application, they've been using it, they consider it a trademark, you might have a problem if you also try and use that as a branding feature.
Well, I was thinking as well, like, thinking, you know, again, back in the food and drink world, like Hendrix with the cucumber as the side or the garnish. So is that registerable? Or the way Magners serve?
Yeah.
You know, it's those kind of killer features that stand out. Is it? I mean, I don't know.
It's possible. I mean, you could say that is a sign which represents your brand. But can you show that people will recognise that it's a Hendrix gin and tonic from the cucumber going in? Probably not. And also, who would you sue? Because, you know, are you going to sue the barman who's just put the cucumber? Because it only infringes your registered trademark, a cucumber in a gin and tonic, once you put it in there.
Right.
So, and even there's also an argument to say that a trademark functions up until the point of purchase. And that sign doesn't exist until you've made the purchase and ordered the drink and they put it in.
Yeah.
So
I don't know, I was just thinking, you know, and again, we've talked about meal a bit, but thinking about, you know, Dead Hippie Burger, their signature wings as well, you know, the chicken wings with the Frank's hot sauce on and all that stuff, and you know, Nando's dishes, but, you know, it's like, are those trademarks?
Yeah, well, there was a lot of debate, you know, for example, Chanel No. 5, the smell of Chanel No. 5. Is the smell of Chanel No. 5 Chanel No. 5's trademark?
Yeah.
But you don't really get to smell it until you buy it. And how would you used to have to be able to represent your trademarks graphically. There has been some changes, so now you can file, you know, an MP3 file if your trademark happens to be, you know, a sound or a jingle. But before, in the days of representing graphically, you had to effectively be able to write out on a piece of paper what your trademark was. And it was that had to be distinctive. And there was a couple of examples, ones that got through where, you know, the smell of fresh cut grass as applied to tennis balls. Of course, you know, that's a clear, concise, you know, objective. Everyone knows what that means. More extreme examples was, you know, do you remember, is it still around, Tynant, the water, the mineral water? I think it's
What was it called?
Tynant. I think it was Tynant.
Don't remember.
I need to check this and go back. But they tried to do the same thing. They had a very distinctive colour of bottle. It was a very vivid chromium blue.
Okay.
So the way that they tried to represent that graphically was they said it's, the colour blue as it's emanating at 680 nanometers or something like that.
Right.
And it was refused on the basis was that wasn't clear. I have no idea. If you said to me, what 680 nanometers blue look like? I don't know.
Yeah.
Is it this blue of the chair? Is it that blue in the painting?
Mm.
Is it a royal blue? Is it what is it? It's not
common understanding.
Yeah. It's not clear.
Yeah.
And even, and there was a time when this represented graphically issue was going about, and you would use a Pantone reference number.
Yeah.
So you would say it was Pantone reference 691C, whatever that is.
Well, that's funny you saying that, because when I was at lastminute.com, they managed to register the pink. Mm-hmm. And it was always a bit kind of 100% magenta thing, but then it ended up being 226C. And I remember I'd left by this time, I think, and I just saw it on the bottom of the website. It just says this colour pink, and a little key as a registered colour for last minute. And I just thought, you're clever. Yeah, well done. Mm-hmm. I thought it was absolutely fabulous.
Mm-hmm. I remember filing a few on the basis of a Pantone reference number. And I found out later that Pantone reference numbers change over time.
Okay.
A Pantone reference number now might not be the same colour as a Pantone reference 10, 20 years ago.
I didn't know that. We've got a bunch of old Pantone books in the office. Better chuck them out, I guess. I didn't know that.
It's a kind of shifting sand, the Pantone reference. But, purple as applied to chocolate. That's a very clear, and you know what it is, and you know what brand I'm talking about.
Yeah, Milka. But I was just kind of thinking through the last couple of things, and what I was thinking about was, just watch outs for people. Is there any absolute common errors that you just think, I just don't want them to make these mistakes,
Common misconceptions that I hear all the time are, and I don't know where these things come from, are, people say things like, if you change 7 things, you'll be all right. Where did you get that from? 7 Samurai? 7 Brides for 7 Brothers? It doesn't make any sense. It's not that simple.
So you mean if there's a conflict on what you've got, you change 7 things?
That is the misinterpretation.
Wow.
I've heard that so many times.
Okay.
You change 7 things. There seems to be some magical thing about 7. Lucky number 7. 7 days in a week, change 7 things. But that's not the case. You've got to take an objective look at what has someone else got protected or is using, and what am I intending protecting or using. And it's a movable feast. Kodak, is still, a massively distinctive brand, will have a huge amount of protection over it because of that distinctiveness. I don't think you could use Kodak for anything else. Kodak has Kodak for 1 to 45 classes. Partly through the distinctiveness of the name, partly through their use. Meat liquor is perhaps not in that situation at the moment because it's not as distinctive. So maybe one change could get you out of infringement of meat liquor's rights. So try not to fall into the trap of thinking there are magical tricks and changes. Be honest with yourself, and also remember that it's a two-way street. If you can be confused with them, they can be confused with you.
And you might get the rub-off, backlash, ricochet from them screwing up.
Salmonella breaks out in their restaurant. If you're too close, you might get the blowback from that as well. Be honest with yourself. Don't get married to a brand. It's a commercial tool to do a job. And if there is a problem with your favoured one, and there is no sensible solutions to that, if it doesn't look as though it might be out of use, or perhaps you could get it revoked for non-use, or perhaps you could come to some sensible arrangement with the owner, try something else. Because something else will work just as well in the majority of cases. Search early. When you start coming up with a short list, check them all out, put them on Google, and if something pops up and you think it's going to be a problem, then chances are it will be a problem for you. If not now, perhaps in 3 years' time, when you've invested much more in your brand and it's going to cost you an awful lot more to change rather than, put a pencil line through it and moving on to the next one. Once you've found a brand that appears available for use, I would get a professional to check it out, to give you that extra layer of security. And if everything looks fine, register it. And then you can prevent other people from using it. And then you won't have the problems associated with someone else coming up with your name.
I mean, it really just does feel like that stitching time saves nine. And, and what you're saying there, I think is a really good piece of advice, which is, the Gary Vaynerchuk, the amazing business guru, I saw one of his gifts the other day, and it just says, you can't beat what you copy. What you copy, you can't beat. And it is just that originality.
Yes.
And I think you'll feel a certain liberation from having that clear horizon and not having anything that you can see with, being able to see for miles with the checks that you do, that anything that's going to infringe or, put your brand at risk.
And like you say, I mean, not only check on, the trademark registry we used to do, look through Instagram, put a hashtag on it, see if there is anything there. Look at it and look at it objectively and dispassionately, and don't think, I could get away with this.
Yeah.
You might not be able to get away with it.
Yeah.
And you might not want to get away with it.
Yeah.
And make sure that if you're going to be using a name, you are the only one going to be using that name.
And then just last thing then is just one takeaway for people, that are thinking about getting into business, creating brands daily, or maybe worried about this. What's the sort of one takeaway from the whole chat we've had?
I would say don't fear intellectual property. It's not a black art. It's there to protect businesses and to protect businesses' reputations and brands. It protects other people's and it protects yours. All that you've got to do is to ensure that whatever you want to use isn't already protected by someone else. And if it is, there's always a plan B. And once you get the trademark or the brand that's going to do a perfect job for you, protect it.
Brilliant. Well, listen, thanks so much for taking the time to sit down and have a chat about this.
Pleasure, always.
And I've learned loads as usual, but hopefully it'll really help people, just stay in the straight and narrow. So I think we should probably wrap it up. Get to the pub with a big red T outside, that distinctive piece of Scottish branding, and maybe have a wee look at some brands in action as we get some dinner later as well. Thanks so much to Stuart William Wallace from S. William Wallace Company for the discussion on intellectual property and brand protection today. Thanks also to Stuart for all his amazing tips and examples and what is really happening out there in terms of brand similarities, brand standout, and how you can avoid brands incurring extra expense when someone else can claim rights to your brand down the track. Thanks also to Gaz, Gabby and Mihal for the production, exec production and design for the Spectacular Marketing Podcast. Don't forget to subscribe on your preferred channel. Tell your friends, leave us a rating if you can, would really appreciate that. And also a review which tells us anything that you like or you'd like to see improved as time goes on. I'm Mark McCulloch and this was Spectacular.